This courtroom session starts off with something you rarely see but immediately feel. An attorney forgetting courtroom attire. A judge enforcing decorum before enforcing the law. And within minutes, we're deep into eviction cases, financial disputes, and legal gray areas that affect real people's homes and livelihoods. Today's docket isn't just paperwork. It's about possession, rent balances, court costs, and whether tenants truly understand what paying late rent actually means. Across multiple cases, we'll see judges wrestle with fairness versus procedure, attorneys push statutory language, and tenants suffer consequences, sometimes despite paying what they thought was enough. You'll hear arguments centered around Michigan eviction law, particularly how courts calculate amounts due, and whether payment after filing protects a tenant from losing possession. So as we go through this session, pay attention to one question that keeps coming up in different forms. When rent is paid, is justice satisfied, or does procedure still win? And more importantly, should tenants still appear in court if they believe they're caught up? Let's break it all down.
Okay, counsel, do you have a tie on?
Right out of the gate, the judge sets the tone. Courtroom decorum matters. Whether it's a missing tie or uncovered shoulders, the court reminds everyone that respect for the process starts with appearance. This may feel minor, but it actually signals something bigger. This judge runs a tight courtroom, and that precision will matter later when legal technicalities come into play.
No, I forgot. I'll go get, you want to pass the matter and I'll go put one on. I forgot.
Counsel, I'm just slightly confused. You're in court. I'm not sure how as an attorney you forget to have a tie on.
I understand. I'll just go do it.
Do you
right
have your suit jacket as well, or what?
now. I think so.
Are you wearing a tank shirt?
I'm wearing a sundress.
Ma'am, okay, your shoulders need to be covered, please. You're in court. Ms. Spicer is not checked in, and counsel?
Your Honor, we would request a default judgment. This is possession only. We did request a second mailing. Rent to retain $1,274. Court costs $180, making the total $1,454. We would request a writ date of November 24th. Additionally, to the best of my knowledge, the property has been habitable during the time of the lease. The defendant is not a minor, nor incompetent, nor in active military service.
All right, and so counsel, is this amount for October or November?
Both, Your Honor. We did file in October, but I did verify with management.
Here where this case gets legally interesting. The landlord is requesting a default judgment, but the judge pauses, and that pause is critical. Why? Because the tenant did pay October rent in full. The only remaining balance is court costs. Legally, landlords may be entitled to recover those fees, but possession is a different issue entirely. The judge draws a clear line. Owing court costs does not automatically justify eviction. This moment highlights a key misunderstanding many tenants have. Paying rent doesn't always erase legal consequences, but it can protect possession.
That they did have a balance carrying over from October into November.
What was that balance?
I would defer to Miss Tanisha Morgan. If Ms. Morgan, you could just unmute yourself and clarify what that balance coming from October was.
And
For
Ms.
Ms.
Morgan,
Spicer.
before you do that, if you can please state and spell your first and last names for the record again, please.
Absolutely. My name is Tanisha, Tanisha. Last name is Morgan, Morgan, and I'm the property manager for Green Trees. That balance effective October 24th, 2025 was $192 going into November.
$102?
No, ma'am, $192.
Oh, 92.
Yes, ma'am.
And was that representative of court costs?
Yes, the legal fee was included in that balance.
Okay, so is the $192 balance, is it strictly legal court costs?
I'm gonna say yes, because the legal fee was $1020. Is when it was charged, it was $200, and the balance was $192 going over.
Okay, so counsel, it appears as though the balance that's currently owing is for November rent, but Ms. Feister paid October rent.
Understood, Your Honor. I would just convene with Ms. Morgan and probably Mr. Katz to just confirm that we could dismiss this one.
Okay, all right, so I'm not going to enter the judgment. Because it appears as though the balance of rent was paid prior to November, and that the balance that's owed is court costs.
Although, Your Honor, arguably, plaintiff is entitled to the court cost by statute. They did file the case. And
I'm not suggesting you're
balance,
not entitled, Counsel, I'm not suggesting you're not entitled to court costs. However, I'm not issuing a default judgment against an individual who paid the rent in full. And then how the balance of that gets recovered, obviously is, up to your client and you, but the court's not entering a default judgment against an individual that paid their rent in full. And
So,
prior to the next month.
but Your Honor, MCL 600.5741 does indicate that the balance at this hearing is calculated at the time of trial. That the judge shall make the finding at the time of trial.
This is a powerful judicial moment. The judge openly acknowledges a systemic issue. Tenants often believe that once they pay rent, they don't need to come to court, and in many cases, they're told exactly that. The court refuses to punish someone who likely misunderstood the process, choosing fairness over strict enforcement. The takeaway: courts can exercise discretion, and here it matters.
The language is mandatory that the finding is done today. That would include November rent and these court costs, Your Honor. It's not just even solely November rent.
MCL 600.5741. If the jury or the judge finds that the plaintiff is entitled to possession of the premises or any part thereof, judgment may be entered in accordance with the finding and may be enforced by a writ of restitution as provided in this chapter. If it is found that the plaintiff is entitled to possession of the premises in consequence of the non-payment of any money due under a tenancy or the non-payment of monies required to be paid under an executory contract for purchase of the premises, the jury or judge making the finding shall determine the amount due or in arrears at the time of trial, which amount shall be stated in the judgment for possession. In determining the amount due under a tenancy, the jury or judge shall deduct any portion of the rent which the jury or judge finds to be excused by the plaintiff's breach of the lease or by his breach of one or more statutory covenants imposed by Section 39 of Chapter 66 of the revised statutes of 1846, as added being Section 554.139 of the compiled laws of 1948. The statement in the judgment for possession shall be only for the purpose of prescribing the amount which, together with tax costs, shall be paid to preclude issuance of the writ of restitution. The judgment may include an award of costs enforceable in the same manner as the civil judgments for money in the same court. So, counsel, while part of that is mandatory language, part of that is discretionary language. So the court is not.
This case raises a recurring tension: court costs versus rent obligations. The landlord argues that unpaid court costs will simply lead to refiling if the case is dismissed. From a legal standpoint, that's not wrong. But the judge isn't convinced that technical entitlement should override practical fairness, especially when rent payments exceed what was originally demanded.
Finding that you're entitled to possession of the premises at this point. Therefore, the court is not required to make a finding as to the amount due or arrears at the time of which shall be put in the judgment, because Ms. Feister paid her rent in full in October, and now we're into a new month. And I understand sometimes based upon schedules and dockets and when things are filed, it may be a bit more convoluted because we're into a second month sometimes for the hearing date. I am not entering a judgment when a tenant has paid rent in full for the month that the complaint was filed that it was not paid.
Understood, Your Honor.
When the rent was paid. And I understand that it was after and that there's court costs that are incurred and that the individual still has to pay those court costs. I'm not suggesting that they don't. However, I'm not entering a judgment at this time. What I'll do though, counsel, is I will set this for a second hearing to determine how those court costs are going to be paid, if that's what you choose to do.
Thank you, Your Honor. No objection.
Because I'm also keenly aware, counsel, that individuals are of the understanding that if they pay their rent in full, then they don't need to appear. So I'm not going to enter a default judgment for Ms. Feister not being present because she did pay her October rent and there was a zero balance of rent carried over, albeit there was still a balance of court costs and attorney fees that carried over. So I'm not in the habit of entering a default judgment on an individual that paid their rent in full and likely misunderstood where the legal costs come in.
Thank you, Your Honor.
The matter of Southgate Apartments versus Divine Johnson, 2501906. And counsel, your appearance for the record, please.
Christopher Borkin, P86265 for the plaintiff.
Okay, thank you. And Ms. Johnson, Ms. Hillebrand, if you can please state and spell your first and last names for the record.
Yes, Wendy Hillebrand, WENDY HILLABRAND.
Okay, thank you. All right. And so, counsel, I think that you had indicated that there, you need to get with Ms. Hillebrand. And what did you determine?
Your Honor, we did not speak additional amounts, but I believe the amounts that may have carried over into November are just court costs. I would have Wendy verify that on the ledger of.
This exchange exposes how messy rental ledgers can become. The tenant paid more than the amount listed in the complaint, yet still faces eviction due to timing and remaining balances. The judge scrutinizes every dollar, and rightly so, because eviction judgments must be precise. A few dollars off isn't a small error when someone's housing is on the line.
Divine Johnson. But Your Honor, plaintiff's position is that we should be entitled to those court costs today in addition to the November rent. If it was just court costs, and if we're just adjourning it over court costs, this issue isn't going to go away. In fact, if we dismiss it, we're just likely to refile over unpaid court costs. And the court is saying itself that we're entitled to them by statute. And I don't think that's the issue. So I guess I'm a bit stumped what we do if it's just court costs that are unpaid. I guess I'm speaking in the hypothetical. That's not going to be an issue at this case, Your Honor, but it will be in another coming. So
Okay.
maybe I'm
Ms.
putting it on the
Hillebrand?
court's radar.
Okay, Ms. Hillebrand,
Yes, Your Honor.
is there something you wanted to state?
Yeah, we are, so for Divine Johnson with her balance being 1737, I haven't had a zero balance on her since 9/24. Since 9/24, she hasn't had a balance, and I've got 2 failed promise to pays on her. So I just wanted to make that noted for her account.
Okay. So all right. So as of October 22nd or October 20th, I'm sorry, this shows rents paid through September 30th, correct?
Yes.
Okay. So then October 1st rent was due $15.99 per month, correct?
Yes.
Okay. So where did we get to the 1836 that says total rent now due?
Okay, I am on her ledger now. So she made one payment on 11/3. She did not make any payment for October. So we did file on her in court for October.
I understand that. What was the amount paid on November 3rd?
November 3rd was the 1865. And now her balance is the 1737. So are we
Okay,
just
so she paid
refiling on
18.
her?
Okay, so she paid 1865. That's more than what was alleged in the complaint. That said rent, late fees, utilities, legal, and other charges.
It needed to be paid by, I thought it was supposed to be paid by 1031. So that I must be misunderstood. I apologize, Your Honor.
Well, so Mr. Borkin, what this court's not going to do is enter a default judgment against a tenant that ended up paying their rent in full for the prior month, and mistakenly or otherwise, presuming they don't need to be in court. I'm not suggesting that November rent is not due, but at this point, the 1865 that was pled in the complaint, well, it said 1836 in the complaint, 1865 was paid.
Your Honor, I would object on 2 grounds. The first being grounds that I stated previously, is MCL 600.5741 does indicate that the amount is calculated as of the day of the hearing. That now includes November rent. And even if the amount in any sort of demand was paid, the rental balance has not been zeroed out. and there is a balance due as of today, a default judgment with a redemption amount is proper, considering all of the other procedural steps that we followed with the second mailing and along those lines. But Your Honor, the balance being 1737 today, being unpaid, including unpaid court costs, we are entitled to a default judgment. The second grounds that I would object, Your Honor, is that I believe it's just generally improper for the court to analyze with this depth the amounts that we are providing. These are relatively some certain amounts, Your Honor. We're testifying based on books and records and the amounts due as of today. And the default itself is an admission to some degree of liability. And procedurally, we are entitled to the defaults, Your Honor, and we are testifying as to those amounts, and they are accurate.
Okay, and counsel, with all due respect, there's significant amount of opportunities that the amounts have not been accurate, and that it's not necessarily some certain, because there may be a last minute payment and ledgers have to be checked and ledgers have to be confirmed, or there was a payment made and that hasn't been confirmed or whatnot. So the court does take exception to the objection that the court doesn't need to be going into this much detail. The court does in fact need to make sure it's going into this much detail to make sure that any judgment that's being entered is established on the record. Because in the event there's a motion filed or what have you subsequently down the road, this all needs to be on the record. The amount due, the amount that's been paid, if there's been amount paid. However, again, as it relates back to your argument regarding 600.5741, if the amount is due, that's due as of the date of the hearing, as you're indicating, counsel, that's only upon the court, the judge or jury finding the plaintiff is entitled to possession of the premises.
I agree, Your Honor, and we are.
I understand that's your position.
But the court has no basis to, because we filed for the non-payment, because we're claiming a redemption amount, because we're claiming the property is habitable. I'm not certain what basis the court could say that we are not entitled to possession with the default over these amounts, over the court costs, over the November rent, over the amount that carried over into November. I guess, Your Honor, how is the defendant entitled to possession? They've not been here to present their case even. And I know the court is saying that they're aware of a problem, but we're also here testifying that that problem isn't present in this case, that we're entitled to these amounts now. And under the facts and the law, it would seem that we should be entitled to the default, and defendant isn't entitled to the possession because they aren't presenting that case. So I don't know how it could be the case that plaintiff is not entitled to possession, Your Honor.
Sir, counsel, the concern this court has is that the individual that, and not even necessarily in this particular case, but just in general, an individual that has a court date, makes their rent, makes their payment in full for the month that the action was filed. Often, this court's been informed that they were told they didn't have to appear. If they paid it in full, they didn't have to appear. So, in many of these cases where the balance.
Ultimately, this case ends very differently from the first. The tenant is absent, court costs remain, and management testifies that tenants are explicitly told to appear if balances exist. That distinction matters. With no tenant present to contest the record, the court enters a default judgment. This contrast shows how attendance alone can change the outcome of a case.
Balance ends up being paid for the month of the previous month that was pled, and the tenant is not present. The court has concerns that the tenant is not present because they were told they didn't need to be present because they paid their rent in full for the month that claims rent was not paid, not for the month that the hearing date is held. So I'm just trying to clarify that for you, counsel.
I understand. Yes.
Ms. Hillebrand, did you have communication with Ms. Johnson?
I have a collection specialist, Sydney, who is unfortunately out today on vacation. I have her notes that she gave me. So whether she was told or not, when she paid on the 3rd, I do know our policy here at Southgate is if the next month is owed, that money is to be paid, or you go to court, because that's how I have always done it. So if you're paying after the 1st of another month and you owe that money, you still have to show up in court. Always.
Your Honor, could I ask a
You don't have
question
a zero balance.
that I think might help a little bit?
Yes, of course.
Wendy, when a tenant comes to pay, particularly when it's close to the end of the month and they have an active court case, 2 questions. Are court costs already on the ledger when they're coming to pay that amount and they have an active case filed?
Yes.
Court costs are already on the ledger, and they're told the amount of court costs
Yes.
as part of the balance that they need to pay.
Yes.
And if they pay that amount, do we dismiss it? What do we do? Or
If
actually,
they are especially at the end of the month or beginning of the month, if they are at a zero balance and they have a court case coming up, we tell them your case will be dismissed. We advise them to still go on to court, but if they have paid to a zero balance, your court case is going to be dismissed. If they are not at a zero balance, especially in a case when there's another rent that hits, right? They are told they need to appear in court.
Understood. So, Your Honor, I believe Wendy's actually testifying to the opposite, that management tells tenants to appear, and that in this case, Divine Johnson, while making that payment and leaving a balance, would have been told to appear in court.
Absolutely.
All right, the court will proceed with entry of a default judgment in this matter as Ms. Johnson is not present. And the amount not due and owing for unpaid rent is, what's that cost, counsel?
Just the court costs?
What's the amount that's due and owing?
The total amount would be $1,737, Your Honor.
All right, the court will note by default plaintiff is entitled to recover possession of the property. I'm sorry, counsel, you went through the habitability, correct?
I don't believe I did.
Oh, okay. If you can do that, please.
Thank you. To the best of my knowledge, the property has been habitable during the time of the lease, and the defendant is not a minor, nor incompetent, nor in active military service.
All right. The court does find then by default that plaintiff is entitled to recover possession of the property, as there was also a second mailing that was completed, and that the balance, that there is still a balance due and owing of $1,865, including court costs and late fees for the month of November. If plaintiff does not pay that in full, plaintiff may apply for an order evicting the defendant by November 24th. I'm sorry, if defendant does not make that payment by November 24th, plaintiff apply for an order evicting the defendant. Additional money may be owed if damage to property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant, and no money judgment will enter at this time.
Thank you, Your Honor.
All right, thank you.
Thank
Have
you.
a good day. Thank you. Have a good day. Green Trees Apartments versus Jennifer Hardacre, 2501909.
Christopher Borkin for the plaintiff.
All right, and counsel?
Your Honor, currently rent to retain is $1,336. Court costs are $180, totaling $1,516. We would request a default judgment. This is possession only, with writ to issue November 24th. If that amount is not paid in full, Ms. Morgan would be here to testify regarding that not being zeroed out anytime soon, anytime recently.
Okay, Ms. Morgan, your name again for the record, please.
Sure, my name is Tanisha, Tanisa. Last name is Morgan, Morgan.
All right, thank you. All right, and when was the last time this was a zero balance?
The last time she had a zero balance was September 19th, 2025. She has made since, this is gonna be another one. She made a payment at 13/16, but the remaining was the court costs.
This case stalls because of uncertainty, and that's intentional. The judge refuses to enter judgment without absolute clarity about what the tenant knew and when. If legal fees were assessed the same day payment was made, the court wants proof that the tenant was properly informed. This hesitation reflects a judicial philosophy that eviction should never rest on assumptions.
When did she make a payment of $1,316?
It was October 20th.
Your Honor, could I ask Ms. Morgan a couple questions?
Oh, yes, please.
Ms. Morgan, when tenants come and pay at, actually, are you familiar with this tenant in particular when they came in and paid that date?
No, sir. I wasn't,
Okay.
no.
No, that's okay. When in general though, when tenants come to pay late in the month, when they have active court cases, are they told the balance as of that day when they're making a payment?
Yes, we frequently send calls and let
Okay,
them
hold
know
on, just
that
1 second.
court is-
Hang on just 1 sec.
Sorry.
Ms. Morgan, and are court costs included in the amounts that so you said, I just want to be clear, they would be told the balance when they come and make a payment at the end of the month like that?
Yes.
And would court costs be already included in that balance? If you have sued somebody, if you've filed on somebody and they're coming in and paying on an active case, would court costs already be on their ledger as they're making that payment?
Yes.
Okay. And so if they were paying off everything except court costs, they would know they had court costs left to pay. Is that correct? They would be told you have X amount remaining, you have $180 remaining.
So when they come in and make the payments and drop off payments, I'm not really sure if we give the balance at that very time, but we are consistently through the month calling and letting the residents know their balances, their incurred fees, late fees, legal fees, so they
Okay.
know they have that balance.
Could you just speak to when court costs are put on the ledger? When are they put on the ledger?
So for the month of October, the legal cost was put on there on October 20th,
Okay.
and that's when she paid.
The same day?
Yeah.
Okay. So would those court costs have been on the ledger at the time she was making the payment, and she would have been aware of that extra amount she needed to pay? I think we froze.
I think she's frozen. The counsel, and I appreciate your questions. The concern the court has is that, I mean, we don't know what date she paid it or not, but it's showing 1501 on the complaint. And you're requesting a judgment of 1516. So where's the extra $15?
I'm not certain, Your Honor. I do not have a ledger. Ms. Morgan would have to. Oh, she just disconnected. Your Honor, could we adjourn this one as well? We would essentially have the same argument as we would have on the Feister matter, and maybe we could just look at the same issue on that day. If just court costs remain, what do we do in terms of dismissing? Would be maybe a fair question for us to.
Okay.
Am I summarizing that question, you think, sufficiently?
I believe so. And so, especially in this matter, right? Both transactions were entered on the same day. Right? So it's possible. Yes. I mean, there's lots of possibilities, but without having anybody to testify directly as to what the conversation was with Ms. Hardacre, then, I mean, for all we know, she could have dropped it off. I have no idea. And who knows if she dropped it off before the legal fees were assessed or not. The hesitation of the court counsel is entering a default judgment on a tenant who's made the payment of the rent in full and may not have known that the legal fees were assessed yet or whatnot. So that's where the court has hesitation in entering a default judgment in those specific situations.
And is it just when the amount is the court costs, or is it when the amount also includes? I mean, in my mind, it was more straightforward if it was more than just the court costs. Is that true?
Maybe more straightforward
It
to
was
enter
more
a default.
Yes, if they had more than just court costs rolling over into the new month, is the court more inclined to do a judgment then?
It is more inclined to do a judgment then, yes.
Okay. And then, Your Honor, would that be adjourned to the same date, the 24th?
Yes.
Thank you.
Did I give you 9 o'clock for the other one?
Yes.
Would you like 9 o'clock for this one?
Yes, please.
Okay.
Thank you very much.
Your P number, counsel?
35262.
Okay, counsel, do you have a tie on?
No, I forgot. I'll go get, you want to pass the matter and I'll go put one on? I forgot.
Counsel, I'm just slightly confused. You're in court. I'm not sure how as an attorney you forget to have a tie on.
I understand. I'll go do it
Do you
right
have your suit jacket as well, or what?
now. I think so. Yes.
Yes, counsel, that's an expectation of the court. Absolutely.
I'll go see if I have a coat and tie. I'm sorry, Your Honor.
We're on the record in the matter of Mike Vigilante versus Rachel Duncan, 2501760.
Good morning, Your Honor. Attorney Tim Way here, P77735 for Mr. Vigilante, who is the plaintiff, who is also in the court via Zoom.
Hello,
All right, and Mr. Vigilante, good morning. Your name for the record, please.
good morning. My name's Mike Vigilante.
Okay, something something sounds off on the audio. Can you pick them up, Allie?
Not possible.
Okay, can you try it again, Mr. Vigilante, please?
Yep, good morning, everybody. My name is Mike Vigilante.
Is that better?
A little bit. It's just very like muffled.
Can you maybe turn your volume down a little bit? I'm not sure if that's why it's muffled.
Yeah, is that better, Your Honor? Can you hear me better now?
Yeah, that's fine.
Yes, that's better.
Okay. My name is Mike Vigilante.
All right, thank you. And Ms. Duncan? Is Ms. Duncan present?
Your Honor, if I may,
Yes.
Ms. Duncan was in court via Zoom earlier today. We were actually put in the breakout Zoom room together. We spoke for brief moments. I don't know why she left the courtroom, but we noticed that happened like about 10 to 15 minutes ago. There was no resolution between the parties, and as far as I know, she talked about getting a state.
This case shifts gears completely. Unlike prior matters, this isn't about late rent, it's about a lease expiration. The tenant leaves the Zoom hearing, fails to submit required assistance paperwork, and the landlord moves forward. What's notable here is the judge's patience in recalculating the landlord's numbers, rejecting inflated estimates, and grounding the judgment strictly in provable amounts.
Support. Last week, she did not submit any document, at least to my office, and I checked the court's record. I don't believe she also submitted anything to the court either. And further, Your Honor, at this point, this is a 30-day notice. This is not a non-payment of rent case, and the lease expired in July 31st. And Mr. Vigilante is simply wants to move forward with the eviction based on the expiration of the lease. So.
Okay, I'm looking on here. Allie, can you check the ROA to see it? It shows that DC form 539 was filed, please. It's been after September 30th. I mean, November 3rd.
I don't show anything after the November 3rd.
Okay. All right, the court will note that her counsel, Ms. Duncan, was present, was in a breakout room.
I'm sorry. Your Honor, I'm counsel for the plaintiff, Mr. Vigilante. Ms. Duncan does not have a counsel.
No, I understand that, counsel.
Oh, yeah, sorry.
as I stated, that the parties were present and per counsel, the parties were in a breakout room and Miss Duncan logged off prior to the court calling the case. And the court will note that per counsel, there was not a resolution in the matter. And also that counsel did not receive the copy of the DC Form 539, which this court ordered on November 3rd. Ms. Duncan was to submit as she indicated she was requesting rental assistance. The court has not received that information. Counsel for plaintiff has indicated he has not received that information either. And therefore, counsel, are you requesting to proceed with the default?
Your Honor.
Okay, you may proceed.
Your Honor, so today's the date set for a pretrial, and I believe that Ms. Duncan has not appeared in court. This is right now the time is 9:30. The case was at 8:30, and Mr. Vigilanti is present in the court, and Ms. Duncan's not present in court, and we let's move forward to request a default judgment on this case, Your Honor.
Okay, counsel, the amounts of unpaid rent and otherwise, if you'd like to state that for the record, please.
Right, Mr. Vigilanti, what's the current unpaid rent?
It's $7,250. I got to be honest with everybody. I don't even really expect or want to. I just want her to get out of the house because I just been working.
Thank you, Mr. Vigilanti. We just need the number. Yeah.
Thank you.
So does that amount include attorney fees or late fees, or is it strictly rent?
No, Your Honor. That was just the overhead rent, the gas, the water, and then it did not include the attorney fee.
What's the monthly rental amount, sir?
It's $1,450, and that included the gas and the water. The last payment was made July 31st.
Okay, so sir, I'm showing it $1,450 a month for August, September, October, November. At 4 months, it's $5,800.
That is correct, Your Honor. I just, you know what I did is I jumped the gun and went to December 1st just because it's around the corner, and I don't think she has any plans of leaving. That's where I got the $7,250.
Okay, well, that's not going to be the amount this court's putting forward. And so, so for the unpaid rent is $5,800.
Yes, Your Honor.
Are there any late fees each month, sir?
A $50 flat fee per month.
Okay, so that's $200 in late fees. Total $6,000. Okay. All right, and what, counsel, what are the court costs?
Your Honor, the attorney's fees would be at $1,500.
Oh, no, there's statutory attorney fees, counsel. I'm not assessing $1,500.
Yeah.
What's that?
I believe the statutory amount, that would be what, $75?
Okay, and then what about the court costs?
Court cost was, I believe, $60.
You believe, okay, counsel, this is your case, so I need to know so that I can put the judgment in.
Just let me double check with the, Your Honor, it's, I believe it's $40.
Okay, so counsel, are you sure it's $40? Because you also believed it was 60. So is it $40 or $60?
Your Honor, just let me double check with the, yes, there's $45. I apologize for the inconvenience. $45 for possession only.
Okay, so the total amount you're requesting then is $6,120, correct?
That's correct, Your Honor.
The court will note this matter was scheduled for 8:30. Parties were in a breakout room and Ms. Duncan left prior to the court calling the matter, and it is now 9:42. Therefore, oh, I'm sorry, counsel, if you can please speak to habitability and status of the defendant, please.
Apologize. Could you repeat that last question, Your Honor?
Please speak to the habitability of the property and the status of the defendant, please.
Yes, Your Honor. So Mr. Vigilante is the full possession of the real property, and property is habitable under the current law, and the defendant, Tenants, is currently holding over. Her lease expired in July 31st. She's currently holding over as month to month.
Okay, do you have any indication that she maybe in the military or
No, Your Honor.
incompetent or otherwise, counsel?
We have no record or anything that led us to believe that she is in the military. The fact that she also did appear in court today.
All right, the court will order by default. Plaintiff does have a right to recover possession of the property. The amount now due and owing for unpaid rent and other costs is $6,120. If that amount is not paid or defendant does not move out on or before, counsel, what's the writ request date?
I believe it's the 10 days.
I understand that, counsel. This is your case that you need to present, so please state it for the record. What is your request for the writ date?
I would like to have 10.
Self-representation is never easy, and the judge makes that clear. From evidentiary rules to document submission deadlines, the court spells out expectations in detail. This moment underscores an important reality. Representing yourself doesn't relax court rules, it increases your responsibility to follow them perfectly.
Days, Your Honor.
Okay, well, specifically the date for the record, counsel.
That would be
It would be November 27th, which is Thanksgiving, so we have to put it to December 1st.
That's fine. Thank you, Your Honor. December 1st will be the requested date.
All right, the court, if that amount is not paid or defendant does not move out on or before December 1st, plaintiff may apply for an order evicting the defendant. Additional money may be owed if damage to property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant, and no money judgment will enter at this time. And the court will sign that upon receipt, counsel.
Thank you, Your Honor. Just additional.
What's that?
Oh, sorry. I thought somebody was speaking. Do you require us to submit a scale form for the judgment, or is the court's going to issue one for us?
No, counsel, you are to submit the form, the court approved form through my file.
Understood. Thank you, Your Honor.
Thank you. Have a good day. Okay. And so what's happening today?
Your Honor, I explained the basis of our complaint. There's several violations of the lease, which is the reason why we notified or we started this complaint, and which involves the failure to pay the full security deposit, the lack of proof of insurance, and then city violations and a lack of certificate of occupancy. So I explained that to Mr. Henderson, and I think that's essentially where we left it. I just, I wanted him to, he has his take on things, and that's where we're at right now, Judge.
Okay, so do we need to set this for an in-person hearing?
Yes, Your Honor.
That would be fine, Your Honor.
All right, thank you for addressing appropriately for court, Mr. Henderson.
Yes, ma'am.
Well, we can, okay. Our jury trial resolved, right? So we could do December 5th?
Yeah. Yeah.
Sorry, you said there's the second time you've had to tell somebody about a phone? Is that the second time you've had to tell somebody about a phone?
Yes.
The phone goes out into the car. Go. It goes outside. Does not stay inside here now, sir. Go ahead, put it outside. Are you hearing something?
That's exactly what I told him.
All right, we'll set this for December 5th for an in-person trial. We can do 10 a.m.
10
Does that
a.m.?
work for you? Does that work
That's
for you
fine.
both?
That worked for me, Your Honor.
Okay, so Mr. Henderson, let me just be very clear, all right? You're representing yourself. So you are required to follow the court rules regarding any evidentiary things, any evidentiary issues that you may have. So if there are documents or otherwise that you want to present that day in court, you need to submit that over to Mr. Sims prior to the date of trial. So I'm going to indicate any witness and exhibit lists to be exchanged by November 24th.
Thank you, Your Honor.
Also,
Thank you,
if there's
Your
if there's any video evidence that either one of you would like to present to the court, you are responsible for making sure you can play it on your own device, whether that's on your device and you screen share it for the court or what have you, but the court does not play videos through its equipment, okay?
Understood, Your Honor.
Okay, we will see you all back on November 5th in person. Have a good day.
Excuse me,
Thank
Your
you.
Honor. Ain't it
you.
December the 5th or is no? Okay, yeah.
I'm sorry.
Yes, ma'am. Okay.
I'm sorry, what was that, sir?
Yes, ma'am. Is this December the 5th, right, ma'am?
I didn't understand that.
He-
It broke up.
Judge, you just misspoke and said November 5th. He's just clarifying it's December 5th.
Oh, December 5th. I'm so
Yep.
sorry. Yes.
No, you're good, Judge. All good.
Well, now let me make sure. I'm pretty sure I typed December.
We're having a hard
I
one.
did.
Yeah.
No, I typed December.
You're good.
Thank you. Have a good
You're
day.
welcome. Take care.
You as well. What's the status?
Yeah, there's been a resolution. The resolution is that the tenants will pay $900 today, $600 on Thursday of this week, and the balance by the last day of this month. And that balance would be
This is one of the few moments of resolution. A structured payment plan replaces immediate eviction, and the judge ensures both tenants fully understand their rights, including their right to challenge the judgment within 3 days if there was a misunderstanding. This case shows how courts can balance enforcement with opportunity when communication is clear and both sides cooperate.
1,160.08.
$1,160.08 would be the balance.
Yes.
Okay. And then counsel, if one of those payments is missing, what is your requested writ date?
The writ date would be December 1st.
Okay, and Kenesha Tagger, did you hear the terms of that judgment?
I did, yes.
Alonzia, did you hear the terms of that judgment?
Yes,
Okay, and you both understand that Mr. Balderman represents the interests of your landlord and not your interests, correct?
yes,
Alonzia?
yes,
Okay, I need to see Alonzia. I can't really see.
yes.
Are you wearing a tank shirt?
I'm wearing a sundress.
Ma'am, okay, your shoulders need to be covered, please. You're in court.
Okay.
So please go grab a sweater or something.
I didn't see him leave.
You also understand your rights that you received in your packet of information. Is that correct?
She's asking you. Yes.
Kenesha, also you.
Yes,
And do you have any questions regarding those rights?
no,
All right, and Alonzia, do you have any questions regarding those rights?
no.
All right. Do You also understand your rights under the court rule, correct? Mr. Balberman, did you explain those rights to the tenants?
No.
Counsel, that is, okay. Explain those rights to the tenants, please.
You have a right to appeal this hearing if you'd like. And if you don't pay the rent by the due dates, the writ would issue.
That's not quite the court rule, counsel. Kenesha and Alonzia, if in the event, because you're not represented by counsel, if in the event you have good cause or you were mistaken about something, then you have 3 days whereby which you can request the court set aside the judgment.
Okay, thank you.
All right. And so knowing all of that, Kenesha and Alonzia, do you have any questions?
No.
All right, the court does find the waiver of rights as valid. The terms of the judgment are reasonable. The court does will order by consent. Plaintiff does have the right to recover possession of the property. The amount not due and owing for unpaid rent and other costs. Well, counsel, what's the total amount due?
Total amount due is $2,660.08.
All right, the total amount due is why did that not type? $2,660, correct?
And 8 cents.
And 8 cents, okay, something didn't go. All right, that amount is to be paid as follows: $900 by November 17th, which is today. $600 by November 20th, the balance of $1,160.08 by November 30th. If any of those amounts are not paid, plaintiff may apply for an order evicting the defendant. I'm sorry, if those are not paid by December 1st. If any of those payments are not paid, then on December 1st, plaintiff may apply for an order evicting the defendant. Additional money may be owed of bail if damage to property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant, and no money judgment will enter. Do you have any questions?
No questions.
Okay, good luck to you all. The court will sign it upon receipt.
Can we sign their name? Can we sign their name to the judgment, Your Honor?
You have to ask them, counsel.
Oh, Ms. Taggers, Kenesha, and Alonzo, is it okay if we sign your name to paperwork with that regard?
Yes. Yeah.
Okay, thank you.
All right. Okay. The court will sign it upon receipt. Thank you.
Thank you.
Have a good day. In the matter of Key Properties Incorporated versus Adam Hammond and Amanda McAuliffe, 2502046. And
Good morning,
counsel,
Your Honor.
your appearance, please.
Good morning, Your Honor. Stephen Ellis representing the plaintiff.
Okay, and have the defendants checked in?
She is on.
I'm here.
Okay, and counsel, did you have an opportunity to speak to Miss McAuliffe in a breakout room?
We did, Your Honor, and we came to an agreement we'd like to put on the record.
Okay, is Mr. Hammond present or no?
He is not present, but my understanding is that we will submit a consent judgment to Ms. McAuliffe, and she will get both of them. Both of them will sign it.
Okay, although I don't have an opportunity to ask Mr. Hammond if regarding his rights because he's not here.
I understand, Your Honor.
So, ma'am, where's Mr. Hammond?
He's at work. He's not, his job doesn't give him the ability to be able to break away to do this.
Okay. So then, counsel, if you want to okay, well, let's put the agreement on the record and then we'll see what we're doing from that. Okay.
Thank you, Your Honor. We've agreed that the redemption amount will be set at $15,275. That court costs and service fees will be added to that, and that the date for paying that amount will be set at January 2nd, 2026.
Okay, $15,000.
$275.
You said January 6th or 2nd?
January 2nd.
Council, how much is the monthly rent?
It is $1,500 a month.
And how much are the late fees per month?
$75 a month.
Okay. So council, here's what, so Mr. Hammond isn't present. I can't enter a consent judgment with Mr. Hammond because he's not present. And so I can't ask him about his understanding of his rights and waiver of the rights since he's not here. However, it showed that he was supposed to have been here. There was a second mailing that was made. And so if you're requesting a default judgment as to defendant 1, we could do that. But I can't do a consent judgment for defendant 1.
Understood, Your Honor. We would request a default judgment against Mr. Hammond. Still, I will send a consent judgment to both parties, and I've worked with them before. I expect them to be able to sign them and return them to us for the court.
Okay. All right. And so, ma'am, you heard the terms of the judgment, correct?
Yes,
And you understand that Mr. Alice represents the interest of your landlord and not your interest, correct?
correct.
And you, in fact, have received your advice of rights in your packet of information. Is that correct?
Yes,
And you understand all of those rights.
yes,
You also understand by entering into this agreement that you'll be waiving some of those rights.
yes,
And you understand your rights under the court rule that was explained to you by Mr. Alice. Is that correct?
I didn't hear the last part you said. I'm sorry.
Mr. Alice, did you go over the her rights under the court rule?
Correct, Your Honor.
Okay. And so, ma'am, do you understand your rights under the court rule regarding the 3 days?
Yes,
Okay. Do you have any questions?
I do not.
All right, the court does find by consent as to defendant 2, default as to defendant 01, as this matter was scheduled for 8:30 and it's 10:04. And per defendant 01, I'm sorry, defendant 02, defendant 01 is at work and unable to appear. And so therefore, the court's going to enter judgment and order that that plaintiff is entitled to recover possession of the property by consent as a defendant 2, default as a defendant 01, in the amount of if the amount of $15,275 is not paid on or before January 2nd, plaintiff may apply for an order evicting the defendant. Additional money may be owed if damage to property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant, and a money judgment will enter based upon the request and the appearance of defendant 2. So that will be as to defendant 2, because I don't believe that there was personal service for defendant 1. Was there, counsel?
Your Honor, we didn't file for a supplemental complaint for a money judgment.
Oh, I thought that's what I read.
No, we didn't file for that. We simply want possession back.
Oh, I'm sorry. There, it was checked off underneath number 10, but number 10 wasn't checked off. Okay.
Correct.
All right, no money judgment will enter, and the court will sign that upon receipt.
Thank you, Your Honor.
Okay, thank you. Do you have any questions, ma'am?
I don't.
All
Thank
right,
you.
thank you. You have a good day.
Have a good day.
Counsel, have you spoken in a breakout room?
Your Honor, we have. So briefly, I just popped in on this matter to handle the landlord-tenant hearing only. Mr. Sandweiss came in, told me he was coming in and that there is an existing bankruptcy. I did go into the Pacer account. I did verify that. So I am requesting an adjournment. It looks like the bankruptcy, there's already been a trustee's report of no distribution. And today, in fact, was the last day to object to discharge. So it appears that we can't really move forward, and I am requesting that this be adjourned until that discharge goes through as final.
Judge, if I may,
Yes.
the plaintiff had actual notice of the bankruptcy filing at least 3 times, maybe 4. The plaintiff chose to ignore the notice and filed this case anyways, in violation of the automatic stay. We will be seeking sanctions in the bankruptcy court for the violation. However, the fact is that the case should be dismissed, not adjourned, because anything that the creditor did, meaning even if they sent a notice to quit in violation of the automatic stay, if they filed a case and filed the automatic stay after receiving actual notice, all of those are void under existing Sixth Circuit law.
Judge Mullins.
And Your Honor, my only comment to that is Mr. Sandweiss did say that to me. And like I said, popping in to handle a landlord tenant, I don't have authority for any of that, which is why I asked for the adjournment, so that the attorney of record could deal with all of that.
Well, where's the attorney of record today?
Mr. Kobolak is out of town, which is, and I'm not sure what the situation was, but that's why when I was in the office early this morning, I was asked if I could just handle this. It looked pretty routine, but it wasn't. So I spoke with Mr. Sandweiss, and that's all that I'm requesting is an adjournment so that he come back in and deal with that. I actually have not spoken with Mr. Orlando. So the allegations that he may have or may have not have had notice is something I really can't address. And I think that because it is a rather serious allegation, that the best way to handle it would be to have the actual proper parties here. That's just my thoughts, Your Honor, if you agree.
And Mr. Sandweiss, are you the attorney that's representing the Penix in bankruptcy?
Yes, I am.
Yeah.
Okay, and so when did you, so then you knew about this matter as well, correct?
I knew about this when my clients called me over the weekend.
You got room up there?
Mr. Flaherty, you are not, you need, stop moving around, Mr. Flaherty.
No, I gotta talk to these people.
Well, Mr. Flaherty, these people are requesting that you stop moving around and stop unmuting until your case is called. Okay, and so Ms. Croto, when is the attorney of record, Mr. Kobolak, back in town?
Your Honor, I'm going to email him immediately after this. I don't know. I mean, he's the partner that I work for. I honestly don't know. But you know, I'm going to reach him by email and by phone.
And so, Mr. Sandweiss, you're available Monday, December 1st?
Am I available December 1st?
Yes.
I have to check my schedule. Hold on one second, I'm looking. If I need to appear by Zoom, I will, but there's no reason for it given the bankruptcy stay.
Counsel, the reason is because I don't have all that information. You just filed your appearance this morning. I don't even have any information in this file online of any bankruptcy at all. So yes, there is a reason for it to be adjourned. I can't just grant your request for dismissal. I don't even have the documents that anybody's relying upon. And Ms. Croto does not even have the information that she needs, even though they're the plaintiff. So yes, there's an absolute reason this court's going to adjourn this. So are you available December 1st?
Via Zoom, yes.
In person?
I will not be available in person because I'll be out of town. I won't be back. I'm out of town now and I won't be back until the 11th of December.
Great. We'll set this for December 12th, in-person hearing.
What time?
11 o'clock.
Okay.
Here, locked at 12, just.
Okay, thank you. That's in person. So Ms. Croto, please let Mr. Kobolak know that that's a firm date. That date's not getting moved and it's in person.
I will do that. And I am looking at his calendar. He's
All
open.
parties need to be present.
Okay.
And if there's any case law you want this court to rely upon, then I would suggest that any briefs that you want this court to rely upon are submitted by December 1st.
Okay.
December 1st is next Monday and it's Thanksgiving weekend in between. Can we get a little bit of an extension on that, please?
So what are you asking for as far as length of extension, counsel?
Either to the, let's say till the 8th, which would be the Monday before.
Counsel, I have to have an opportunity to review the case law and research it if it's something that I'm not familiar with. And given my dockets, and I'm the only judge in this court, I need a little bit longer than 4 days. So that's why I indicated December 1st.
How about December 4th, Judge? That'll give you a little over a week.
December 4th by noon.
Thank you, Your Honor.
All right, thank you. Have a good day.
You too.
So,
Huntington House Apartments versus Elijah Roberts, 2501950.
Christopher Asphalt, 53129 on behalf of the plaintiff.
Okay, and is Elijah Roberts present? No, okay, he has not checked in at the court either. And counsel, what are you requesting?
I would request entry of a default judgment for possession. There's currently rent to retain $4,665.91. Cost $176.54. Total $4,842.45 with a writ to issue date of December 4.
Okay, so counsel, just a quick question. Did you confirm whether or not the keys were received? Because my notes from November 14th show parties were present. Defendant stated defendant relocated and that we were setting it for a second hearing today. And upon return of the keys by defendant, plaintiff was going to dismiss.
It looks like they did just put in a message saying that the house keys have been returned, but not the mailbox or the laundry keys. So based on that, I assume that they think that they do have possession of the property back.
Okay, counsel, I'm not going to I'm not entering a judgment like this. When the plaintiff or the defendant was present last time, indicating it was going to be dismissed upon return of keys, I'm not going on an assumption. So we can do one of two things. I can either have you contact your client or we can set this over for Wednesday for you to determine whether or not that has all been done.
Yes, why don't we set it over for Wednesday, Judge? That is what the note indicates, yes.
But not mailbox or laundry?
Correct. So I'll confirm for them if they consider that they do have possession of the property back and it's okay for us to dismiss.
All right, November 26th at, we do 8:45.
Yeah, 8:45.
8:45 a.m.
On what date, Judge? I couldn't hear.
Wednesday, November 26th.
Very good.
I mean,
thank you.
November 26th. Yes. Okay. All right. Thank you. And I believe that's all of yours, counsel.
Yes. Have a good day.
Okay.
This courtroom session offers a powerful lesson in how eviction law actually plays out in real life. Paying rent late doesn't erase court costs. Missing court, even when you think you're caught up, can change everything. And most importantly, judges aren't just rubber stamping paperwork. They're weighing fairness, credibility, and clarity in every decision. Some tenants were protected because they showed up or because the court refused to rely on assumptions. Others lost possession simply by being absent. The difference wasn't always money. Often, it was understanding the process. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.